Welcome to Jenna Ellis Tonight. My name is Jeff Hunt, filling in for my good friend Jenna Ellis. Did you see the U.S. Supreme Court case decision that came out yesterday? Well, Joe Biden definitely did, and he dissents, it declares Joe Biden. Check out this video from his speech last night.
Today's Supreme Court decision on presidential immunity, that fundamentally changed. For all practical purposes, today's decision almost certainly means that there are virtually no limits on what a president can do.
Ron Coleman, an attorney and host of the Coleman Nation, joins Jenna Ellis tonight. Thanks so much for joining us, Ron.
My pleasure. Good to see you.
So I got to ask this question. Are we now a dictatorship in America? That's what Joe Biden seems to think.
Yeah, well, he does seem to think that. He's always conducted his presidency as if we are a dictatorship. He has routinely ignored the Supreme Court. He has enacted numerous illegal policies. He has disregarded the law. His administration has disregarded subpoenas. Now, however, now that the United States president is no longer the only federal employee, and certainly federal executive employee, to have immunity, qualified immunity for official acts, as opposed to every single prosecutor, every single state prosecutor, every single local prosecutor, every single judge, every single dog catcher. It's the end of the world. It's great.
Ron, I got to ask you, I would think Joe Biden would like this because, look, I want to create a scenario, right? Let's say your daughter is attacked, assaulted, and murdered by an illegal immigrant that this federal government captured and then released. You're a little angry about Joe Biden's open border policies and you want to sue him for it. Yesterday's Supreme Court decision is going to protect him because wouldn't he be acting in official capacity?
Well, that's a case that would never fly anyway, regardless of whether the president himself is immune. You'd have to demonstrate that the president was the one who made that decision and that he was proximate cause. Generally speaking, though, the reason this doesn't help Joe Biden is that this Justice Department or any Justice Department will never prosecute Joe Biden for anything he does. They basically already said that he's too feeble and worthless as a defendant from a trial point of view. And that's now. It's not getting any better.
Now, Ron, I want to get your response to this tweet. This tweet had to do with Sotomayor's dissent. According to the Supreme Court, Biden could now send in SEAL Team 6 and take all of them out. He could send in the military to take out Trump. He has, quote, immunity, unquote, for all official acts. Now, this is one of Joe Biden's biggest young supporters. Is he wrong in his legal analysis?
I wouldn't call that legal analysis. It's more distressing, though, that he's not misreading the dissent. That is what a person who is paid to make legal analysis at a very high level actually does suggest. So it's not a Harry Sisson problem. That's a separate and serious problem in and of itself. It is I don't want to name names, but it is a problem with the left-wing conception of how to read decisions and how to politicize decisions. It's ridiculous. Those would never be official acts. There's nothing in the Supreme Court's opinion that suggests that they would be official acts. And again, it's not really a change in the law. It's just a Supreme Court recognition of a legal doctrine that everyone has always taken for granted. Just no one ever thought that suing ex-presidents for policies would be a norm that we'd be living through.
Now, Ron Coleman, it looks like there's a few different buckets that a president's activities could go into, right? One could be official discussion or official decisions made by the president of the United States of who they're going to appoint to be an ambassador, who he may attack as a foreign enemy without necessarily having to go to Congress for a declaration of war quite yet. But then there's activities that fall outside that. And the U.S. Supreme Court did not say that all activities that a president does are protected by immunity if they're outside of official acts. Can you talk about what an activity outside an official act may be?
Well, the court reiterated the decision in Clinton when President Clinton, non-tragically, non-fascistically, non-end-of-the-worldy, tried to say that he should be immune from all acts while president, or immune from any lawsuits while president, by virtue of being sued for private conduct, sleazy private conduct. Supreme Court said, no, that's not what immunity is for. Immunity does not protect you for your solely private acts. In between is a world of conduct that may involve powers of the president that are not core powers. Things that a president can do by virtue of being president, but that are not essential to his executive functioning. Those are qualified immunity. Those are eligible for qualified immunity, not absolute immunity. It's going to be interesting for courts, and in fact, the court in this particular case, the very partisan and how shall we say it, hasty district court in the District of Columbia that decided this without a hearing, on the fly, and in a sort of throwaway way, that there was no issue of immunity. The Supreme Court said, take a look at this indictment and make findings, and if necessary, take evidence in order to ascertain what are the non-covered, non-official acts that this indictment covers. Election-related stuff is an interesting gray area. I mean, we learned this during Watergate with respect to the Nixon cases. So, you know, it could be interesting, but we have not heard the last of this in the appellate courts and maybe even in the Supreme Court, because we are still dealing with a sort of less than ideal judicial temperament and intellect handling the January 6th cases. And the district court in that circuit has been more or less, how should we put it? I'm doing a lot of, I'm trying to use my words carefully here, because I'm a member of these courts, enabling that conduct.
Ron, it seemed last night that Joe Biden was most upset about the idea that these cases weren't going to be heard before the election. So is it likely that because of the decision yesterday and the reevaluation that the lower courts are going to have to go through, this is going to take some time? We're not going to get answers before the November election.
It is likely. And that goes for a number of other cases that are affected by this as well. It is, look, the cynicism that was baked into this entire process, the whole idea that these cases were brought to for the sole and all but explicit purpose of interfering with the elections, that's blown up in their faces. They thought they had it all figured out. And eventually the Supreme Court had the opportunity to weigh in. And again, I think it will do so again. I hope it's a Supreme Court, when it does so again, that we can live with.
Ron, we only got about 30 more seconds. It seems like the biggest concern coming out of all of this is that the president of the United States is now a dictator or king. I'll give you the final word to reassure the American people that we're still a republic.
We're still a republic. The dictator, the king, not a thing.
Yeah, thank you so much. Ron Coleman, an attorney and host of the Coleman Nation. Thank you so much for being on Jenna Ellis tonight.
My pleasure. Catch you later.